Welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This is my weekly series covering what matters most in data privacy, and this week we have two important developments worth your attention. First, the Texas Attorney General has filed a lawsuit against Netflix, not under Texas's comprehensive privacy law, but under an older consumer protection statute. And this choice of legal theory is creating some notable enforcement patterns. Second, New Hampshire is on the verge of passing a bill that would prohibit the sale of certain children's data, regardless of whether the seller knew the data belonged to a child or had parental consent. It's a short bill, but as we'll discuss, it may have meaningful implications for some companies. Let's get into it. Texas Attorney General Paxton has sued Netflix, alleging violations of the Texas Deceptive Trade Practices Act. The core claim is straightforward. Netflix made representations to consumers about its data practices that don't match what it actually does. Specifically, the complaint alleges that Netflix misrepresented that subscribers wouldn't be subject to data-driven advertising and that children wouldn't be subject to behavioral data collection. And it alleges that Netflix's disclosures about how it shares user data were vague to the point of being misleading, without sufficiently describing practices like identity matching, clean room collaboration, and programmatic advertising to enable consumers to understand what was actually happening. Now, here's what makes this case worth watching closely. Texas has a comprehensive privacy law, the Texas Data Privacy and Security Act. But the AG didn't bring this case under that comprehensive law. He brought it under the older Deceptive Trade Practices Act. That's not the first time we've seen this choice. When Texas sued General Motors over privacy violations, it also used the Deceptive Trade Practices Act, not the comprehensive privacy law. Now, there may be a few practical reasons for that. The Deceptive Trade Practices Act allows for higher penalties, up to $10,000 per violation, compared to $7,500 under the comprehensive law. The Deceptive Trade Practices Act also doesn't require a 30-day notice and cure period before the AG can act, which the comprehensive law requires. But the more significant reason may be that the Deceptive Trade Practices Act gives the AG a cleaner narrative. The comprehensive law has specific defined parameters for things like sensitive data, sale of data, and dark patterns. Fitting conduct into those categories requires careful legal analysis, and it doesn't always work cleanly. Deception is a simpler story. You told consumers one thing, you did another. What's interesting is that California showed us a different path with the same conduct in its case against GM. When California took action against General Motors for the same underlying activity, it used California's comprehensive privacy law, the CCPA, enforcing its purpose limitation and data minimization principles. Texas has a narrower comprehensive privacy law without California's strict purpose limitation requirement, but it was still able to take action against GM using the Deceptive Trade Practices Act to fill the gap. The takeaway for companies is that a privacy program that technically complies with the requirements of a state's comprehensive privacy law is not necessarily a complete shield against enforcement in that state. And where the state's comprehensive privacy law doesn't provide the tools necessary to bring a claim, the Attorney General might just find another way. So you can offer all the required opt-outs, have a thorough privacy notice, and satisfy every checkbox under a comprehensive privacy law, and still face significant liability if your consumer-facing representations don't reflect what you actually do with the data. That means companies should be running two parallel assessments. One maps your data practices against specific statutory obligations. The other takes a step back from the weeds of the technical requirements and asks whether the full picture of what you've told consumers in your privacy policy, your marketing, your product descriptions, really anywhere, accurately reflects reality. That second assessment is often the harder one. And based on what we're seeing from regulators, at least in Texas, it may now be the more important one. Okay, let's now turn to New Hampshire, where the legislature has sent a bill to the governor that would amend the state's existing privacy law to prohibit the sale of location and other sensitive data belonging to children. The bill is short, essentially a single operative sentence, but interpreting it carefully reveals some meaningful complexity. Under New Hampshire's existing law, a child follows COPPA's definition, which means children under the age of 13. And sensitive data covers categories like health data, biometric data, geolocation data, and other similar categories that you see in other state comprehensive privacy laws. And notably, personal data collected from a known child. And here's what makes this bill interesting. The bill is worded to prohibit the sale of location and other sensitive data belonging to children, and doesn't include a separate knowledge qualifier. In other words, for the sensitive data categories it covers, and for children's location data, businesses can't rely on the defense that they didn't know the data belonged to a child. Additionally, because the definition of sensitive data includes personal data collected from a known child, the prohibition on sale extends to any personal data of a known child, not just sensitive data. If that's not enough, there's one more layer of complexity to this one-line bill. The bill uses the word location without defining it as a standalone term, separate from precise geolocation data. If location is interpreted more broadly than precisely geolocation, then businesses that currently sell less precise location data, like for example, city level or IP inferred location data, may face new restrictions they hadn't anticipated. The practical implication is that companies selling sensitive data categories covered by the law may need to either stop selling that data entirely or implement age verification measures to confirm that none of the data in a given transaction belongs to a child under age 13. The tricky question, and bear with me, that gets into the weeds, is that if you gain knowledge of age through such age verification measures, does that child become a known child, making all personal data collected from that child sensitive data? Because as you'll recall, the definition of sensitive data includes personal data collected from a known child. If the answer to that question is yes, then for companies implementing an age verification mechanism, the prohibition could apply to the sale of all personal data of children under age 13, not just sensitive data. So really, the choice is between stopping the sale of sensitive data entirely or implementing an age verification mechanism, and for children who indicate they are under age 13, stopping the sale of their personal data entirely. That's certainly a stricter regime than COPPA, which applies only to services directed at children and allows for parental consent. New Hampshire doesn't seem to be offering that same flexibility. Taken together, these two developments point in the same direction, even if they're coming from different places. In Texas, the lesson is about the limits of technical compliance. A company can check every checkbox under a comprehensive privacy law and still face significant liability if its public representations about data don't match reality. In New Hampshire, the lesson is about the limits of knowledge-based defenses. If this bill is signed, businesses won't be able to rely on not knowing that data belong to a child, at least for the categories it covers. Different mechanisms, but a common thread. The margin for ambiguity in data practices continues to shrink. Whether you're dealing with what you tell consumers or what data you're moving and to whom, regulators and legislators are increasingly closing the gaps that companies have historically relied on. That's all for this week. For the full analysis, take a look at this week's newsletter. I'm Julie Rubash. Thanks for joining me. Until next time, go enjoy a little privacy, please.